Thanks for joining us. I'm David Horrigan, eDiscovery Counsel and Legal Content Director at K-Cura, and we're here at the University of Florida EDRM 4th Annual Discovery Conference. I'm pleased to be here with Jason Pill of one of the nation's preeminent law firms, Phelps Dunbar. Jason, welcome.
Thank you so much. I actually went to the University of Florida, so for me it's a homecoming in a way.
Aha, go
So,
Gators.
yes.
I did not realize that.
Yes.
We have got a lot of Gators here joining us today. That's great. I went to law school here at the University of Florida, and so it's great to have fellow Gators. How'd you get involved in eDiscovery?
Well, when I was here, the law school actually had a class, just actually back up in that corner.
Yeah.
And Bill Hamilton was teaching it along with Ralph Losey, another preeminent eDiscovery scholar. And so they were teaching it, it was going on about, and I happened to have the unfortunate circumstances of being roommates with Ralph Losey's son.
Ah, Adam
So
Losey,
Adam Losey
another
and I,
eDiscovery lawyer.
Yes, lawyer, educator, etc.
Yeah.
So anyways, he and I were roommates, and so he always talked about this eDiscovery thing, which you hadn't really heard about much at the time. This was, mid-2000s, and I was intrigued, and he was convincing me it was the most important thing I could learn while I was here. So I took his word for it and took the class with Bill Hamilton and Ralph Losey, and then hit the ground running.
Hey, that's great. When I went to law school here, eDiscovery was maybe a 10-minute conversation in civil procedure class, and of course that building didn't even exist, but
Right.
we're only talking about the 90s. It really wasn't that long ago, but we've seen tremendous change in technology and people's knowledge of eDiscovery. In your practice, do you find your clients are more tech savvy than they used to be, or is it still a challenge to get Luddite lawyers and clients who don't know tech to get on board?
It's certainly a mix, but everyone's progressing in the same direction, just at different speeds. So we're all heading to the city, we're just taking different taxis to get there. So some clients are well ahead of the curve, and they've got sophisticated systems in place. Maybe their businesses were better postured to transition easily, they were electronic-based businesses. Other businesses where there's maybe more of a history of paper products and more hard copy documents, the transition may be slower, the systems have been a little more difficult to put in place, but they're all working towards that. So there's a lot in place right now, a lot of progress that's been made, and they realize it's more cost effective to do these things, because if they don't take these measures, they're going to have to, or there's going to be more money on the back end, whether it's more review, whether it's just some type of burden or inefficiency that's created by not adapting to these changing technologies. So we're all getting there, but you can certainly see the shift excuse me, as clients are progressing towards more familiarity with these concepts. It's a much more fluent language we speak now with in-house counsel, and even as you can see it kind of trickle down to the managers and the supervisors and the folks that we deal with. They're becoming more fluent in these terms. They now know what a legal hold is.
Shocking.
They've received them.
Great stuff. Well, Jason and I are going to be speaking together. We're co-panelists on a panel about the case psyche and getting ready for your case. Jason, if you don't mind, why don't you tell our viewers a little bit about what we'll be discussing this afternoon?
Well, what we're going to talk about is really how you best get into your case at the outset, because there's a whole whole world of work, I should say, that you do before discovery begins. And sometimes before you even get the case, maybe you know about the incident, maybe you get the demand letter, but what do you start doing to formulate your case if you're prosecuting it or if you're defending it? What type of case are you going to put together? What's the narrative you're going to tell? Because in your mind, you're going to have some sort of theories to advance. The client's going to have a narrative of why they took these actions, why they didn't, and then hopefully you're going to get the data to support it. And then sometimes the data doesn't match up and you have to change that narrative, or stories change. So you've got to be able to be very fluid and flexible in what you're doing, and getting that information to start developing strategies and themes that are going to permeate the entire case. And they're going to start at the outset and really drive where you go.
Great. Any particular war stories that you want to give us a preview of that you may be sharing with us?
Well, there is one that comes to mind about a little incident that ended up blossoming into something much larger, where we had a very innocent seeming termination that led to discovery of some other information on that employee's emails that then led to what became a very significant lawsuit about a employee that we didn't realize was planning to leave and compete against our company. And it only came about because someone else was terminated and certain emails were pulled up. And it just shows you how quickly things can expand once you start digging around and you see what's actually there.
the Sherlock Holmes doctrine of eDiscovery. Please join Jason and I this afternoon for the Case Psyche panel. I'll be sharing some of the tales of case law where eDiscovery has played an important role in getting ready for the case. Jason's going to be sharing some of his war stories and his experience, and we're looking forward to it. Jason Pill, thanks for joining me.
Thank you so much, Dave.
Good to see you.